respect, my Lord Witness, it refers to some sort of a formal statement. All that Sergeant Mukhan was doing was to an explanation, and he says, I was at work, and that defense is pursued. Suppose, my Lord, for one moment, that if the explanation that the accused gave that he was at work, if the matter any further, it could have never been the intention, and even with the judgment that my learned friend has referred to, that where an accused gives an explanation, that the formal process that my learned friend wants to at establishing whether a formal statement or a statement should be obtained from the accused that was obtained, to which the investigating officer embarked upon, that a form should be completed, and the form speaks for itself. It talks about a warning statement. It talks about the involvement of the prosecutor, the station commissioner. We submit with the greatest respect it envisages a process where a formal statement is intended to be taken from an accused. And if one looks at a discussion under this topic, it all results under section 217, which deals with the confession. So we submit, my Lord, that with the process that my learned friends wants to embark upon is if, or in the case where a statement of some sort has been made, we also want to refer to the judge's rules, my Lord. We know that they have, as it were, been taken over or subsumed by the Constitution. But these rules still serve as a guide.
What is that, 1946?
Yes.
1940
and 1931.
41, when
yes,
I was under tutor.
They were approved at a conference in Cape Town in 1931.
Yeah.
And administrative directives for the guidance of the police force. And it says the judges' rules are mainly of historical interest because they are longer in effect, their role having to a large extent been taken over by the norms in the Constitution. The following is important. They nevertheless remain general guidelines for the police and the courts for the everyday conduct of police officers in respect of suspects. And in this instance, we want to refer to Rule 5, which says, where a person in custody wishes to volunteer a statement, he should be allowed to make it, but he should first be cautioned. And this is contained in Section 35, which distinguish between an arrested person and a detained person. And Section 35 states that the person in detention and custody should be informed of the right to remain silent, to be informed promptly of the right to remain silent, and of the consequences of not remaining silent, and not to be compelled to make any confession or admission that could be used in evidence against that person. So if one looks, once again, my Lord, this buttresses the point that we are of the view that in this instance one cannot really say that the accused made a statement, because if one looks at subparagraph C, says not to be compelled to make any confession or admission that could be used as evidence against that person. And the same is reiterated in Section 35(2) pertaining to a detained person. And in this instance, the detained person also includes a suspect who's in custody, as it was held in the Sibajan case. But to come back to the judge's rule, number 8 says other words, that he's got a right to not to make a statement